that we used to deal with. But now, as this slide will indicate, actually the next two slides, that's not the way it necessarily is today. While this type of operational control violation does in fact still exist, I found that there are certain, I've come up with at least 5 scenarios concerning air carriers and/or air carriers and uncertificated entities. And they seem, and this is what appears to be the types of operational control violations we have today. That doesn't mean that evolution will be stopped dead in its tracks. They may evolve into even more intricate problems, but we'll deal with what we have right now. The first is loss of operational control within the air carrier. And generally you have hands-off management that results in inadequate controls and systems over its own operations. I'll be discussing a case, North Coast Aviation, that deals with that issue. The next is loss of operational control within the air carrier, where the exercise of operational control is performed by a person who's not approved by FAA. There was a recent NTSB decision last February, Aero Leasing, Inc., regarding that we'll discuss. The third is loss of operational control internally and externally, and it's sort of like a mixed bag, where hands-off management resulted in the surrender of operational control to the carrier's ostensible remote subsidiary. Now that was an Eastern Region case, and Eastern Region, well over a decade ago, did a terrific, maybe it was more than 15 years ago, did a terrific case in investigating that case and bringing them to action. They also made a classic video of it, which I recently saw. And you had some people in this room who, you know, some of us can still recognize them, but I'm not sure everyone can. And, but it was something like President Bush going on the air carrier and saying mission accomplished, because we made a statement at that time that this will never happen again. And obviously it has, but we too learn from our mistakes. That was the Air Maryland case, by the way. The next is loss of operational control externally, surrender of operational control to an uncertificated entity. That's the Darby Platinum case. And the fifth one is sort of Darby Platinum exponentially. And that's loss of operational control externally, where the air carrier rents or franchises out its air carrier certificate to uncertificated entities. And I'll talk about 2 cases. American Air Networks, that they were located in St. Louis, and American Flight Group, which was operated out of the kitchen of a house in Annapolis, Maryland. And we'll deal with that too. Okay, North Coast Aviation. In that case, the air carrier had inadequate controls over its own operations to stop violative flights that were authorized by a gentleman who was the vice president, director of operations, and also held a 25% ownership interest in the company. The individual, his name was Donald Evans, he acted as pilot in command on 3 cargo flights using an aircraft that was owned and operated by North Coast Aviation. He operated the flights when he knew the aircraft was not in an airworthy condition because, 1, he knew that the 100-hour inspection was due and had not been accomplished, and the aircraft had not been approved for return to service. He knew that 2 ADs were overdue. He also knew that the ELT inspection was overdue. He also operated these flights when the aircraft was type certificated for a passenger seating configuration when the aircraft was not in compliance with the manufacturer's recommended maintenance program or another maintenance program approved by the administrator. Prior to these flights, he also disconnected the Hobbs meter. He also intentionally falsified the load manifests of each of these flights by inserting an N number that was different from the aircraft that was being operated. In addition, he falsified the flight and duty times by also inserting an N number that was different from the N number of the aircraft that was being operated. Now, the issue here is not whether the carrier authorized this vice president director of operations to violate the federal aviation regulations. The issue is whether the carrier took adequate action, had adequate systems and controls in place to identify the problem and deal with it. The FAA took action against the carrier to revoke its certificate, and the NTSB held when an air carrier empowers such a high-level official, a person with substantial control and responsibilities over the day-to-day operations of the carrier, to conduct operations on its behalf, the carrier is responsible for violations committed by its vice president, director of operations during the performance of the carrier's business. In this case, the carrier's failure to remove this individual from authority or control after first learning of these serious safety violations during the performance of this business demonstrated that the carrier was either unwilling or unable to act responsibly. Now, if you read between the lines here, what does it tell you? It tells me that if after the first flight the carrier had identified the problem, had systems and controls in place to deal with it, such as getting rid of this individual and making sure that they better track their operations, while the FAA would have taken enforcement action, it probably wouldn't have been revocation. More than likely, it would have been a fixed period of suspension or a civil penalty action. So what's the lesson here that we all should learn from this, especially those who are in the industry? An air carrier must have adequate controls and systems in place to remove an official from a position of authority over flights conducted under the ostensible authority of its operating certificate. And I'll also add adequate systems in place to track operations and identify such problems. Aero leasing. This is a case where an unapproved person exercised operational control on 3 flights spanning a little over 12 months. The first flight was a cargo flight in 2004. The second and third flights occurred in 2005, and there were passenger carrying flights. Well, who was this unauthorized person? It was Daddy. It was the owner certificate holder's father, who was a person based on his violation history the FAA never would have approved in a management position or as someone who could be designated to exercise operational control. Now, Aero Leasing's Operations Specifications authorize only the Director of Operations to exercise operational control. The General Operations Manual, however, permitted the Director of Operations to delegate exercise of operational control to the Chief Pilot. With respect to the 2004 cargo flight, this was an aircraft that had been configured to haul passengers. However, Dad, the unapproved person, without knowledge of the Director of Maintenance, had the aircraft reconfigured to a cargo aircraft, and what they were hauling were 17 pregnant sheep. And I stress that because it's pretty funny. The attorney who represented Aero Leasing, who I think spent a little time here in the Eastern region, by the way, as an attorney over a decade ago, he had an argument that didn't pass the laugh test. There's an exception in 135 for pets. And he argued that these 17 pregnant sheep were in fact pets. Now, no one really believed that, and as the audience laughed, I guess so did the administrative law judge. So he didn't buy off on that either. In addition, the carrier didn't have an FAA approved or accepted operations or training procedures for safely transporting livestock as cargo. With respect to the 2 passenger flights in 2005, at that point in time, Aero Leasing had neither a director of operations nor a chief pilot. And that, once again, authorized these flights. Well, the ALJ found in the board found in our favor, revocation was affirmed. And the lesson that we learned here is quite simple, that an air carrier can only use approved persons to exercise operational control on its behalf. And where a carrier conducted 3 flights for compensation or hire and permitted operational control to be exercised by a person who wasn't approved by the FAA to do so, revocation was appropriate. Now again, you got to read between the lines. I think if the son would have booted dad out after flight number 1 and would have put in appropriate controls with regard to the exercise of operational control, while the FAA would have taken enforcement action, it probably wouldn't have been revocation. But in this case, the violations continued. There were no systems in place to identify and deal with them. So revocation was, in fact, appropriate. Now, these are 2 instances where it was internal loss of operational control. The next case, Air Maryland, is a little bit of both. And I find the facts in Air Maryland kind of unique, and hopefully someone couldn't be as naive and as hands-off management style as the folks at Air Maryland. Because in Air Maryland, well, let me back up. At about the time that Air Maryland obtained its air carrier certificate, the Eastern region revoked on an emergency basis Buffalo Express's air carrier certificate. Now, Air Maryland's CEO, a gentleman named Cadwalader, arranged to lease several aircraft from Buffalo Express's principal, a guy named Broderdorf. Now, shortly after Buffalo Express's certificate was revoked, Broderdorf called Cadwalader with a plan to regain lost business. Well, red flag, what lost business? He has no business anymore. He lost his certificate. That should have put Air Maryland on notice. Now, under this brainstorm, Air Maryland would base leased aircraft in Buffalo and would perform charters for Broderdorf. Again, red flag. Now, the 2 agreed to a tentative working agreement, which was later to be reduced to writing. Now, under this agreement, a division of Air Maryland would be established in Buffalo, and Air Maryland was supposed to retain operational control over this Buffalo division. Broderdorf was not supposed to be placed in a management position. Rather, he was to serve as a sales agent and consultant in billing and collection procedures. The Buffalo division was to keep its own records and have responsibility over its own accounts payable and accounts receivable. Buffalo Express would establish a checking account in its own name, but there was supposed to be a notation that said a division of Air Maryland. And here's a real good one. Profits were going to go as follows: 10% to Air Maryland and 90% to Buffalo Express. And then they began operations. So what's the indicia of loss of operational control? Almost everything I said before, but I'll say it again. Buffalo Express kept its own records, own accounts payable and receivable, own checking account. Profits were divided 90% to Buffalo and 10% to Air Maryland. Believe it or not, this has to surprise you. Buffalo Express's checks had no notation, made no mention of Air Maryland. When FAA investigators queried passengers who paid for flights conducted by the supposed Buffalo division, they had never heard of Air Maryland. They understood the flights were being conducted by Buffalo Express. Now, this goes to the sophistication of Broderdorf. The invoices that Buffalo Express issued to the passengers thanked them for flying Buffalo Express. He really must have thought he was never going to get caught, because that is pretty dumb. In addition, Buffalo Express placed an aircraft that crashed back into Part 135 operations when Cadwalader specifically directed them not to do so. So, in other words, now, even before Cadwalader and Broderdorf memorialized their arrangement in writing, Cadwalader of Air Maryland had inklings that something had gone amok here, because he discovered that Buffalo Express was sending out invoices in its own name. In addition, he learned that Buffalo Express had falsified flight manifests in order to make them appear to meet insurance requirements. So, in other words, Air Maryland and its CEO ignored signals that its ostensible Buffalo division was operating in air transportation as if it held an air carrier certificate, and did little to involve or inform itself of the day-to-day running of the Buffalo division's operation. So, our lesson learned. Again, Air Maryland's hands-off management, which resulted in inadequate controls, is no excuse for failing to maintain responsibility for operational control of flights conducted by its remote Buffalo division. So what do you do if you're in this business? At the first indication that a problem exists, you, as a certificate holder, have a duty, a responsibility, both to your company and the flying public, to take swift and appropriate action to deal with it. And if that means canceling the deal or arrangement you have with a guy like Broderdorf, you do so, because what's at jeopardy is your own certificate. And make no mistake about it, we will take action once we learn about it and investigate it and can prove the violations to protect the public. And in this case, there was only one way to protect it: to revoke the certificate of Air Maryland. Darby. One of the things you'll notice about Darby, unlike the three cases, the two air carrier cases I just discussed, North Coast Aviation and Air Maryland, where we revoked the certificates, American Air Network and American Flight Group, where we revoked the certificates. In Darby, we pursued an emergency action suspending the air carrier certificate until Darby demonstrated, or could demonstrate to the satisfaction of the FAA, that it could exercise operational control. Now, Darby is a little different than the next two cases I'm going to discuss, and that's because Darby was like two different operations all wrapped up into one. Darby owned 4 or 5 of its own aircraft. And with respect to the aircraft that it owned, there really wasn't an operational control problem. They got into problems when they started leasing aircraft from aircraft owners. So, in this case, Darby entered into what I'll characterize as an illegal charter management agreement with Platinum Jet Management, which did not hold an air carrier certificate, allowing Platinum to exercise operational control over passenger flights for compensation or hire. When you looked at Darby's op specs, it authorized Darby to conduct operations under the business name of AlphaJet International. Those op specs also listed the owner lessors of the 6 aircraft that were on Darby's aircraft that were being leased to it. The owners were listed as DBAs, and as Doug said, they were different from Darby. They were not a marketing name of Darby. These were the aircraft owners. They should have had no place being listed on the op specs as DBAs. Now, further look at Darby's op specs and manuals would have showed us that neither Platinum nor any of its officials were authorized to exercise operational control on behalf of Darby. Now, some other facts that are interesting. The broker who arranged the February 2nd, 2005 flight that crashed at Teterboro understood that Platinum was the air carrier. The certificate of insurance identified Platinum as the, quote, charter operator. The pilot in command of the flight hadn't been trained under Darby's program. And what I find really interesting is testimony of Mr. Brasington, the president and CEO of Platinum during the Darby proceeding. He testified that because of the amount of work involved in obtaining an air carrier certificate and in monitoring a Part 135 operation, instead of getting a certificate of its own, Platinum would operate under another company's certificate. Now, isn't that sweet? And how can that happen? It shouldn't have. That is renting out a certificate from an air carrier to an uncertificated entity. Some other interesting facts. Citibank, who owned the aircraft and leased it to Platinum, who in turn to Darby, in their financial arrangements prohibited the lessee from using the aircraft in commercial operations. And some interesting aspects of the charter management agreement. Under the agreement, Platinum, not Darby, provided the crews and paid for crew training and was responsible for ensuring crews were trained. Platinum paid for backup crews. Platinum provided aircraft liability insurance. Platinum paid for maintenance. Platinum paid Darby a flat monthly fee of $2,000, notwithstanding how many flights were conducted in a given month. And I find this was really intriguing. In the charter management agreement, it said that Darby would be Platinum's exclusive agent for Part 135 flights using that aircraft. What in the world would the 135 certificate holder have need for a non-certificated entity being its exclusive agent? It makes absolutely no sense and is one hell of a red flag. So what happened? We went to hearing. And during the course of the hearing, we presented all this evidence that demonstrated very clearly that Darby had relinquished operational control to Platinum, and Platinum, in essence, operated all the flights using that aircraft, including the flight that crashed in Teterboro. The administrative law judge, he agreed that it was an illegal 135 flight, but he found that Darby had nothing to do with it. They didn't have knowledge of it. He was wrong, by the way, and that it was done by Platinum. And he based much of his decision on the fact that the team from Teterboro, which was not the office that administered the certificate of Darby, that was in Birmingham, Alabama, he said that team, they didn't go and do a base inspection, and that's what their handbook says. And if you don't do a base inspection, how in the world can you determine who has operational control? I'll submit that was about as short-sighted an analysis as you can find. And I think the board agreed, because the board held that the fact that a base inspection was not accomplished by the Teterboro team, that was not determinative. There was plenty there to show that operational control was relinquished to Platinum. The board held that Platinum, not Darby, controlled the initiation, conduct, and termination of each individual flight listed in the emergency order. And those three terms, what is that? That's the definition of operational control. Now, I'm going to diverge for a moment, and I spoke a moment ago about emergency suspension as opposed to emergency revocation. Now, emergency suspension, all the FAA has to do is show that a reasonable question has been raised with regard to the qualifications of the certificate holder. That's a lesser standard than proving a violation, which must be proven by a preponderance of the evidence. Notwithstanding the action that we sought, the board not only found that Platinum controlled the initiation, conduct, and termination of each individual flight, they found that the FAA proved that by a preponderance of the evidence. That is very significant. They went on to say that Platinum provided the crew in the aircraft, controlled the crew and aircraft scheduling, accepted charter flights from the public, handled flight planning, exercised many of the operational control functions that should have been the sole province of Darby, including designating the PIC for each flight, specifying the conditions under which the flight could be released, such as weather minimums, flight planning, airworthiness of the aircraft, aircraft loading and fuel requirements. They went so far as to say that Darby did not give any meaningful authorization to Platinum to conduct flights. Darby merely received fax notifications of flights. And by the way, when they received these fax notifications, in the 18 months of existence of their arrangement, they never disapproved a flight. So the final holding really was that Darby surrendered operational control of the flights to Platinum based not only on the charter management agreement, but also on the manner in which the agreement was carried out. Now, the board's decision also caused some angst or consternation within FAA because it pointed out problems within FAA, quite frankly. The board said that the Birmingham FSDO's knowledge and approval of the character and substance of the management agreement does not preclude the administrator from taking a position that differs from one of its FSDOs. It went on to say that the administrator can and should overrule its FSDO's position if she believes it's incorrect and may be inconsistent with air safety. But even more importantly, the board confirmed that the FAA will take action in an individual case when the FAA tells that an immediate safety concern is present. Now, why do we do this? I alluded to it when I first started, and that was that we have a duty and responsibility to develop civil aeronautics and safety in air transportation. And when that does not exist, we have a duty to take whatever action is appropriate. And in an individual case, it would be to take these type of remedial actions, emergency suspensions or emergency revocations. Now, it also led us to work with industry to go on these seminars and to educate ourselves better as to what the requirements are. So we took a two-pronged approach. Doug alluded to the Alaska Airlines case, and that's a very important case because under our regulatory scheme, while you can contract out certain functions that comprise operational control, a carrier cannot contract away its responsibility to make sure that these functions are properly performed, and its accountability if in fact they're failed to be performed. Now, Alaska Airlines, they used a repair station to perform maintenance. And in that case, Alaska Airlines said, hey, you just go after that repair station. They're the ones who screwed up, because we could have only identified this problem if we would have torn the aircraft apart. I'm not so sure of that, because each air carrier, each major air carrier these days, I believe, has a representative at the repair station to make sure that things are being performed in accordance with the carrier's approved maintenance program and to monitor the maintenance. But be that as it may, it doesn't matter, because the decision maker held, just as the regulations require, that the carrier is accountable for the maintenance that's performed. They can contract it out.